Current trends case brief between marital Huggins and the Crown. Citation R.V.Huggins, 2014 ONCJ 64. The defendant is an older student in university. She agreed to be a surety for a man charged with robbery. The bail order required him to be under house arrest unless he was in the company of his mother or the surety. While awaiting trial on the robbery charge, the man sold cocaine to an undercover police officer several times. 3 of the transactions happened in a motor vehicle in which the defendant was also present. The Crown charges her with being a party to these offenses and joint possession of cocaine later found at the home. She denies all knowledge of defendant's activities. The defendant testified that on March 24th she was driving her motor vehicle with Mr. Brown as a passenger, en route to her home when the latter told her he wanted to meet a person who knows many people and will sell many tickets. He asked her to stop at a plaza so he could drop off flyers and tickets. She complied with this request and explained that a man came into her car and quickly left as she looked out the window. The defendant testified that she did not feel the need to be friendly with the man because he had entered her car without being introduced and said nothing. She stated that she did not find it odd that no words had been spoken during this brief meeting, but later questioned Mr. Brown about his ill-mannered guest. The defendant testified she has never been involved with drugs and had no knowledge of the cocaine Mr. Brown sold to the undercover officer or that found in her home. She reiterated that she believed Mr. Brown was promoting his business and providing related flyers and tickets to the undercover officer. She said she has also used her motor vehicle for this purpose because the nature of the parties attract untrustworthy people and buyers and sellers of tickets do not always want to reveal where they live. The defendant denied observing drugs in her car at any time and she explained that she did not hear any conversation between the 2 men in her car on March 29th as the radio was on and loud. The defendant also conceded that Mr. Brown had stayed overnight at her home on several occasions in violation of the bail order that required him to reside with his mother. There were no legal issues in this case. However, there was the issue of her testimony that she claimed to not know what was going on between the undercover police officer and Mr. Brown in her car, and that she was looking away. The defendant is guilty of 3 counts of aiding and abetting another person in trafficking of cocaine. It is not disputed that Mr. Brown sold cocaine to the undercover officer on 3 occasions in the defendant's car and that she drove the vehicle on 2 occasions and was a passenger at the final transaction. Moreover, if she knew the meetings were about cocaine, there can be no question she aided Mr. Brown in trafficking because her car was used for this purpose and he could not be in the community unless accompanied by the defendant or his mother. However, the defendant insists that she did not have such knowledge and believed the meetings were about Mr. Brown's party promotion business. The judge rejected the defendant's evidence as it was taken into account the fact that she knowingly allowed Mr. Brown to violate the terms of his release by staying overnight at her home. As such, it may not have troubled her to be the necessary escort for Mr. Brown to engage in more sinister pursuits. In any event, it is difficult to accept that a mature and educated woman could so easily be duped by Mr. Brown into believing that his quick exchange with a stranger in various parking lots on 3 occasions had a legitimate business purpose. Moreover, if it is inconceivable that the defendant failed to notice that Mr. Brown did not at these encounters deliver flyers or tickets. These paper products have nothing in common with raw cocaine. The defendant's answer to these obvious challenges is that she simply did not see or hear what was happening. It didn't make any sense at all that the defendant would look away while transactions were conducted with respect to a business in which she was actively involved. It is incredible that she would ignore a person reputed to be able to sell many tickets and thus assist her and Mr. Brown in their party promotion business. The fact is that the drugs and money were exchanged by two men seated beside and behind the defendant. She could not fail to see and hear. She had to know the true nature of the transactions. In coming to this conclusion, the defendant was found that there was an absence of evidence and that the defendant personally profited from the drug deals. The Crown claimed that the evidence proving the defendant is a party to drug trafficking is also compelling evidence that she implicated with respect to the cocaine found in her home. In the circumstances of this case, the judge disagreed. There is no reason to believe the defendant would allow crack cocaine to be in her home in plain view and readily accessible to her children. There could be little to I thought the judge handled this case very logically. I think it is unrealistic to believe that the defendant could be in her car with two other men and have no knowledge of what was going on between them. I also thought it was very logical of the judge to overlook the claim made by the Crown against the defendant of possession of cocaine regarding the cocaine found the defendant's home after the search warrant was executed, as she had two kids there, and it's unrealistic that she would be okay with having cocaine readily accessible to her two kids.